Cool. Okay. So the next question is a very, very interesting question. It's a long one. I'm going to ask it with the best summary as possible, but both you and I know that to try to answer something like this is extremely difficult because of the different designs and constructs that we've experienced when it comes to specifically the supply of electricity. So in this scenario, the supply of electricity was basically, they would say, disconnected. So the supply was somewhat hampered or terminated. There's no longer a supply. Now, the reason for this is there's a metering company. So in the middle between the municipality and this tenant is a metering company. And this metering company was basically saying that there was arrears and there were several notices that they claimed to have been sent that would have been sent to the owner, but the tenant should have known he was in arrears. So now you have the owner saying he never received these notices from the metering company. The tenant saying had he been aware, he would have paid, but also actually being in arrears with the metering company anyway. And now, basically, long story short, there's this little debate, but it comes down to the fact that now the tenant has to pay reconnection fees and a whole range of things that he's claiming the landlord should be responsible for, and the landlord is claiming that he should be responsible for. So that's the gist of the question, Nick.
Perfect. Yes. So what I'm going to do, as you say, this is a very difficult and a complex question, both in our law and in particular because of the surrounding facts of each circumstance. And unfortunately, this is the fee that's been rendered in this case is a 220 Rand fee. So this is not something you're going to go speak to an attorney about. So I'll try give you broad strokes. But the crux of the question at the end of the day is the landlord asking whether they can levy the fee on the tenant. That depends on your lease agreement, whether if there's a fee incurred, who does that exactly get appropriated to? So go look at your lease agreement. More generally, with regards to these sort of problems. So obviously, supply of electricity in our modern day is quite a complex thing. Generally, this is done by a municipality. A municipality supplies electricity to the occupants and ratepayers within its area of jurisdiction, and the municipality has certain rights that it has as a result of the supply of electricity, including the ability to terminate electricity in the event that electricity is not paid. The municipality has certain steps that they have to take before they can do that to make it legal. And for instance, if there's a dispute with regards to a meter, they are precluded from terminating until such time as that dispute is dealt with effectively. Okay, most people within society then underneath the municipality do not have those same rights. Okay, so I want it to be very clear. Lots of people and lots of landlords we get in think that they have some ability to terminate services because there's a non-payment. And unfortunately, that is simply not how it works within society. The municipality has a specific right that's written into legislation. Landlords, metering agencies, etc., don't have a similar right. But there are very clever ways that metering agencies have done different things and how body corporates have done different things, okay, in order to create not a right of termination per se, but a right not to supply electricity in certain circumstances. So, for instance, the introduction of the prepaid meter. Prepaid meters were something that 10 years ago, when we were sitting in our industry, were a non-event. There were no such thing as prepaid meters, but they are increasingly becoming something that is implemented and installed, especially in new developments. When you're going to have a big development with lots of different tenants or occupants, prepaid meters are becoming sort of a standard that's being put into these things. And what happens with prepaid meters, obviously, is if you don't load onto your prepaid meter, no electricity comes out. It's not a termination, okay, per se. You're not getting the electricity, but it's because you haven't put in the money to make the meter actually work in the circumstances. That's just one example of the different types of arrangements and forms that are coming out within the law, and the way people are arranging these things. And I want to be very careful about this particular question because we don't have the details of how exactly this metering company works, what agreements are in place and how the actual structure is. And that's really where the answer to your question is going to be. So there are circumstances where courts have held that a metering agent who issues tokens to owners within a particular sectional scheme, refusing to issue a token because of an arrear account is absolutely enforceable by law, and the court says there's no problems with doing that. So you can, in effect, not sell electricity or provide tokens for electricity in the event that there's a non-payment, but it entirely depended on the facts of that case and the agreement that had been struck between the metering agency and the body corporate and the owner in the circumstances. But in those particular facts, the court upheld that it was fine. That is not to say that every circumstance is fine. If there are plenty of other cases where a body corporate has elected to terminate the electricity services of a particular owner, and courts will go the other way. So it's really a factual question in the circumstances. It does depend on the agreements that have been entered into between the parties. And in particular, this question, your metering agency has levied a fee or penalty against the owner for non-payment of the or non-timeous payment of the account. That too is going to come down to the agreement that has been entered into between the body corporate itself and the metering company itself. So I can't give you a specific answer on this particular question, but I can give you a little bit of guidance. Please go look at the agreement that's been entered into between the body corporate and the metering agency. That will give you guidance as to, can they levy a penalty? What will that penalty look like? And if it's not in that agreement, that is a flag that you should say, well, actually, you can't render this, but it's likely there. And then secondly, this is coming from an agent. Can we levy this to the tenant? That will then depend on what does your lease agreement say about penalties that are levied against the property, and can that actually be levied against the tenants in the circumstances. So I'm afraid it does depend, to the writer, it does depend on your factual circumstances. You'll have to go do a bit of research. This is something that you could absolutely go see an attorney about, and they would help you. But obviously, it being a 200 Rand dispute, you're going to have to do a little bit of work yourself today. And I hope that gives you a little bit of guidance. Perfect.
Oh, awesome, Nick. Yeah, that was great. Thanks so much.
Hundreds. And I think that brings us to the end of the day. So thank you, Bruno.
Yeah.
And we'll see you next week.
Cool. Awesome. Cheers.
Cheers.